In the current report, despite its reference to the fact that violence in general is unpredictable, not a comment that the psychiatrists I've just quoted from have made. Nevertheless, the current authors, two psychologists, write, as the reader can see from his gaffe store, Mr. Sirhan is making an excellent recovery in a relatively highly structured environment such as the protective housing unit. He is considered to be at present, and I want to emphasize this, among the healthiest of the prisoners within CDC. He has learned the system well enough to flourish within its boundaries. He is to be commended and encouraged because of his adaptive skills. I don't see one reference in any of these reports to any suggestion from a battery of trained doctors, psychiatrists, and psychologists, to so much as a scintilla of a suggestion that Mr. Sirhan's release into the community would present any danger, that he's violence prone, that he's likely to go off, that he's likely to do it again, or anything again that's antisocial. And I think that speaks far more eloquently, these professional opinions by employees of the Department of Corrections, doctors, than comments about whatever explosive writing or statement that Mr. Sirhan may have made in the early 1970s while under the stress of a death sentence. Now, Mr. Trapp remarks that Mr. Sirhan shot Robert Kennedy from nearly point-blank range. And that comment is consistent with another document that's in the board's file. It's called Circumstances of Offense under 1203.01 statement. And I'd like to read just a couple sentences from that and then comment on this observation, because it's consistent with what Mr. Trapp said today. In the early morning of June 5th, 1968, this defendant stepped from behind an ice machine located in the pantry area of the Ambassador Hotel. He placed a .22 caliber revolver against the head of Robert Francis Kennedy, firing the fatal bullet into his brain. The defendant fired 2 additional shots that hit Senator Kennedy. Now, the reason for Mr. Trapp's comment, I believe, and the reason that this comment is in the report today, is because of the autopsy report. And the autopsy report states very clearly that the gun from which the shots were fired that struck Kennedy was either in contact with or no more than 1 inch away from his head when the fatal shot was fired, and from 1 to 3 inches away from him when the other shots were fired. The reason for that determination by the autopsy surgeon, and no one has disputed it, is because a number of tests were conducted. One of them was a muzzle test. The revolver, a similar revolver, was test fired with similar ammunition. And this test firing created various powder dispersal patterns. Those powder burn patterns were compared with powder burn markings, tattooing, on the body of Senator Kennedy and on his clothing. And it was determined on the basis of that comparison that the distances between the muzzle of the gun and the body and clothing of Senator Kennedy were, as I've just indicated, point blank to 1 inch in the case of the fatal shot, and 1 inch to 3 inches in the case of the other shots. So nobody's ever disputed that. But let's look at the sentence again. He placed a .22 caliber revolver against the head of Robert Francis Kennedy. Well, that's where the problem is, you see, because no witnesses testified that he got that close. The witnesses place the gun that Sirhan was holding at between 1.5 feet and 5 feet away from Kennedy's body.
Excuse me, Counselor, are you going to re-adjudicate this case? I'm not going to allow you to do that.
No, but I think that I am entitled...
No, you're entitled to speak to suitability of the parole of Mr. Sirhan. We're not going to re-adjudicate the case. We're not going to retry the case. If you want to retry the case, file an appeal and go through the courts.
No, I understand. I was simply trying to direct myself to what I consider to be an important factual inaccuracy in the board's file about the circumstances under which the crime took place. Obviously, this is a telling inaccuracy, because if the witnesses placed the gun as far away as they did, then it would have been physically impossible for Mr. Sirhan to have fired the shots that killed Robert Kennedy.
It's not relevant to this hearing.
I understand your position. But I did want to address that one comment in the board's file. The board's summary of the crime also merits comment for an additional reason. The implication is that Mr. Sirhan was able to continue firing after the hotel employee grabbed him. I would say that the hotel employee in question, the maitre d' of the hotel, has been very clear that he deflected the gun after the second shot, that he grabbed Sirhan and flung him against an adjoining steam table.
Again, Counselor, he stands convicted of that charge.
Right.
We're not going to re-adjudicate that. That is something you're going to have to take up with the courts if you got an argument with it.
I understand. If I can have just a moment, please. Mr. Trapp remarked that during his trial, Sirhan confessed, and he cites this alleged confession as one of the circumstances supporting his conclusion that the offense was premeditated. I think that it's necessary to explain the context in which this particular outburst occurred. What happened is that Mr. Sirhan and the District Attorney's Office agreed to a plea bargain arrangement under which Mr. Sirhan would be allowed to plead guilty in exchange for immunity from the death sentence, so that his sentence would be, under this plea bargain, life with the possibility of parole. The judge refused to accept that plea bargain. Mr. Sirhan continued to have disagreements with his counsel, who in fact never litigated the question of whether he was the person who shot Robert Kennedy, and simply advised the jury, we concede that Mr. Sirhan shot and killed Robert Kennedy. The only issue you will have to consider is his level of culpability, his level of criminality, the nature of his criminal intent. These disagreements between client and counsel caused Mr. Sirhan to make a motion before the court discharging counsel. That motion was denied. It was in the context of these disagreements that that particular explosion by Mr. Sirhan, referenced by Mr. Trapp, took place. This was not a guilty plea. It wasn't even accepted by the courts as such. It was simply an outburst, and that's all. And I think it makes absolutely no sense to characterize that as indicative of Mr. Sirhan's state of mind. What tells us about Mr. Sirhan's state of mind, since the issue has come up of questioning his claim of amnesia, is his own testimony at trial. And if I can have just a moment, I will find the pertinent documents. It's a good time to address this because in its 1990 decision, the panel wrote, quote, "The panel finds that the prisoner's denial of any planning of the offense, his amnesia and selective memory regarding the events that occurred on the date of the killing are indications of lack of remorse and failure to accept responsibility for the crime." I would like to take this opportunity to disagree with that rationale. If someone doesn't remember what it is they're supposed to have done, is that a basis for punishing them? That's what happened in the Middle Ages when people were persecuted for having visions, for what was in their minds. Today, in modern society, we're supposed to be punishing people for what they do, for their conscious acts, not for an inability to remember what it is we tell them that they did. There's a difference. Lack of recollection about what he is supposed to have done doesn't equate with lack of remorse. I just read you an excerpt from a psychiatric report which documents his extreme remorse. He's again and again at hearings over the years, again and again, spoken in very moving terms about how tragic these events were, how he wishes that they hadn't happened, and about how sorry he is that they did happen.
We're at somewhat of a disadvantage, counsel, in that we've not heard your client say any of those things, so we don't know what his position is on remorse and all the other issues that you're raising. Your client has not talked to us about those things.
His statement in the past was the same as it is today, which is that he's very remorseful about the events, but he doesn't have any recollection as to what it was that happened. And I would like to read you very briefly, since the issue of his memory is so important in this, a brief excerpt from his trial testimony, because I think it's extremely telling. I'm quoting from page 5214 at sec of the trial transcript. And he's being questioned by his attorney. And at this point, he's being asked about events that took place in the Ambassador Hotel, but before the assassination. Question, did somebody pour you a cup of coffee? No, as I was pouring my own coffee, some girl came up and said that she wanted some coffee too, and I like my coffee with cream and sugar, lots of cream, and that's exactly the way she liked it. Did that surprise you? Well, I thought I was the only one that liked too much cream in his coffee. So I gave her the cup that I had meant for myself and poured myself another cup. Was that girl alone, or was there someone with her? I don't remember exactly, sir. Do you remember what this girl looked like? She had some dark hair. Dark hair? Yes. Do you have any idea approximately how old she was? About my age. Good-looking girl? Beautiful. Did you engage her in conversation? As long as the coffee was being served, I told her how I would like to drink some coffee too. How much coffee did you have, if you recall? I don't remember, sir. How much? What happened next? I don't remember. What was the next thing you did? The next thing I remember, sir, I was being choked. Do you remember anything between the time you had the coffee? Anything? No, sir, I don't remember. Now, you have heard the testimony in here of at least a dozen witnesses, I suppose. Yes. That were standing in the pantry? That is what I later learned in this court, sir. Well, you have learned it before that. Yes, I did, Mr. Parsons, one of his attorneys, that is. That you walked up to Senator Kennedy and put a gun toward his head, possibly within an inch or two, there's the autopsy report again, and you pulled the trigger and he eventually died? Yes, I was told this. Now, you believe it's true? Obviously, sir. Then he continues, let me ask you this. Did you know in the early morning hours, that is, after midnight of the 4th and the early morning hours of the 5th of June, that you had shot Senator Kennedy? Answer, no, sir, I did not. When was the first time that you remembered that you were accused of shooting Senator Kennedy? Answer, when this Mr. Jordan, and this is the only man that I remember because of his name, Jordan, that he took me to this courtroom and I was in front of a lady judge. I remember that. I couldn't believe it, sir. That's the first lady judge I ever have seen in my whole life. And she started reading these names, and Kennedy was on the list of names. Do you remember those names? Many names. I don't remember them. I don't remember them. Let me ask you this. When you were in the police station at the Rampart Station, and then he goes on, let me ask you this, Sirhan. You have told this jury that when you came to the Ambassador Hotel that night, you didn't come there with any intention of shooting Kennedy. Is that right? That's correct, sir. And you don't remember shooting him? I don't remember shooting him.
Is there a point to all this?
Well, I think the point is very clear that what is called his claims of amnesia were asserted from the very beginning in his trial testimony. And he still doesn't remember having committed any crime. He also doesn't remember having written these notebooks. He was hypnotized before trial by experts on both sides. The amnesia was not shaken even by the hypnotic process. I don't think we can punish somebody for having amnesia. I don't think we can infer that they have a lack of remorse because they don't remember what it is we tell them that they've done. For some reason, he doesn't seem to remember. We don't know why, but we know that he doesn't remember. We can't punish him for that, or we shouldn't punish him for that, and we shouldn't deny him release on parole because of that. If I can have just a moment, please. There has been a great discussion today from the District Attorney's Office about these notebooks, and I mentioned that Mr. Sirhan didn't remember writing them. He also advised his psychiatrist, a defense psychiatrist, that some of the writing didn't look like his. The issue, characteristically, wasn't explored by his attorneys at trial.
It's not going to be explored today either, Counselor.
I understand. I just wanted to mention that the authenticity of the notebooks was never explored. Now, there are some additional factors that we should consider, in addition to what I've mentioned already. As has been established by comments from Mr. Gillis, Mr. Sirhan has no juvenile record Why is that important? Because the guidelines that are supposed to govern this proceeding state that that's one of the circumstances tending to show suitability. And I'm referring, of course, to Section 2281 of Title 15 of the California Code of Regulations. Does he have a stable social history? Well, this is something that needs to be discussed. I notice in past decisions that the board has on occasion said, well, he doesn't really because he grew up in war-torn Palestine and he experienced bombings as a child. Well, I agree that that's an unstable childhood. I don't think it's fair of us to chalk that up as a brownie point in favor of keeping him in custody because he had a hard childhood. I think the question of whether he has a stable social background has to do with what's waiting for him when he gets out. He has a family that's been supportive of him for years, with whom he can live now. He has a brother with whom he's corresponded, who visits him religiously, and who is supportive of his attempt to look into various questions concerning his case that have arisen in connection with destruction of evidence by the police. So I think that there's no question but that he has a stable social history, and that factor militates in favor of granting parole. Signs of remorse, he's repeatedly expressed remorse. It's in the psychiatric reports, it's in the board files, and I'm telling you it still exists today. His lack of criminal history, that's another factor. Well, as already mentioned, he has no criminal history. And that perhaps is an unusual feature for a board such as this, because you deal with lifers who have long rap sheets. Mr. Sirhan has nothing. No record of crime whatsoever other than this one offense, which he can't remember committing. Another question is, does his present age reduce the risk of recidivism? Well, he's 50 years old. There's no sign of any repetition. The psychiatric reports, which are the best evidence of what kind of a risk he is for parole, make it very clear he's a good risk. There isn't one of these psychiatrists who suggested he's no good for release on parole. He's a danger to society. That suggestion is not in here. Institutional behavior. His institutional behavior has been superb. Mr. Gillis correctly mentioned, or perhaps it was Mr. Lander, I believe, excuse me, that Mr. Sirhan had his last write-up back in the early 70s. He's been discipline-free for 22 years. That's a remarkable history. And I think the board is in the best possible appreciation to that, the best possible position to appreciate that, because all day long in lifer hearings, you hear cases of people with substantial disciplinary records that prevent them from getting out because of disciplinary problems, because they get involved in fights or things like that. They don't adjust in the facility. Mr. Sirhan has a totally clean record, most unusual from your standpoint, and most commendable. In fact, as has been mentioned, he earned an Associate of Arts degree here. He got straight A's. He's an excellent student. The letter from Miss Mangan documents the fact that he's an avid reader and is excellent at doing research. His plans for the future, well, he's got a job waiting for him to do research. He's very interested in various constitutional issues that have arisen in his case. He's taken note of a request by other victims as well as prominent citizens in the United States made before the LA County Grand Jury for an investigation into acts of misconduct by the police department in connection with this case. Those acts of misconduct include wholesale destruction of evidence, crime scene material, photographs, and the like. He's taken a great interest in that and has followed those developments very closely. So his plans for the future would include scholarship and research, and he has a job waiting for him and a home in which to live with a family that's supportive, with absolutely no indication that he constitutes a danger to society upon release. Is this man a danger to the community? Well, the psychiatric reports say he's not. His institutional behavior says that he's not. His plans for the future say that he's not. His lack of any criminal history except for this offense says that he's not. His expressions of remorse say that he's not. And again, I emphasize that the question of whether Mr. Sirhan killed Robert Kennedy, while it's not going to be litigated today, was never proven and has never been proven. The only thing that's been proven is that he pulled a gun and fired shots. Robert Kennedy died. It's not been proven that Sirhan's bullets hit Robert Kennedy. As I said to you before, and I won't belabor the point, but the physical position is such that his bullets could not have touched Robert Kennedy, but that issue wasn't raised during his trial. So the problem is the district attorney's office has never proven its case because they never had to. His lawyers just gave it away and rested on a mental defense. I look at the axis that governs indeterminate sentences, and I note that the maximum sentence allowable, assuming a finding of suitability, even in the case of a murder involving torture, is 22 years. And this was not a murder involving torture. This case would be governed by Axis 4B, as I read it, which is 15, 17, and 19 years in its ranges. Well, Mr. Sirhan's been here 26 years, way over the maximum axis, for the description of the offense of which he stands convicted. You're absolutely correct. This board is not authorized to set aside someone's conviction because of constitutional violations, because of ineffective assistance of counsel, because of newly discovered evidence, because the police destroyed evidence that would demonstrate his innocence. You're not authorized to grant any of that relief. But I think it's very clear you are authorized to grant one form of relief, which is to authorize his release on parole. We ask you to do that at this time. And I would also like to state at this juncture that because our research into the circumstances surrounding this offense is continuing, many, many serious questions, many raised by the grand jury petition applicants, have emerged. We are more than willing to meet with prosecuting authorities and discuss our concerns about irregularities in the investigation and prosecution of this case and about newly discovered evidence. I've been asked by Mr. Sirhan to extend an invitation for such a meeting to the DA's office.
This isn't the time or the place to do that, Counselor.
I understand. I'm simply making the
Counselor,
point.
this is about the third or fourth or fifth warning I've given you on this subject. I'm not going to warn you again. This is not the place.
Right. I conclude my remarks with a request that you grant release on parole because there's no indication that he's a danger to society.
Thank you. Mr. Sirhan, do you have anything to say to the board regarding your suitability for parole?
If remorse is the only point that you're going to deny me parole on, I think that it is not fair because throughout this commitment, I have expressed remorse, and only recently have I been more concerned about remorse and the issue of crime in California and society. I understand that you are the father of a person who was a homicide victim, and so are you, Mr. Gillis. I don't know if I'm right or wrong, but the rumors in the PHU unit say that you are. And it saddens me that you have to go through, the experience of losing a family member, and the Kennedys as well. It saddens me all that people have to be killed and lost through violence, and I regret that. Not just as a matter of my action, but in general, people should not kill, period. And I mean that with all the sincerity and forthrightness that I can muster to you, if that's what you wanted to hear, Mr. Gillis. Thank you.
Thank you. Okay, we're going to recess at this time. It's 2:15. Okay, we're back on the record in the matter of Sirhan Sirhan, ID number B21014. Panel reviewed all the information received from the public, relied on the following circumstances in concluding that the prisoner is not suitable for parole and would pose an unreasonable risk of danger to society and a threat to public safety if released from prison. This offense was carried out in an especially atrocious, cruel, and callous manner. The offense was carried out in a dispassionate and calculated manner. Multiple victims were attacked and injured, killed in this or separate incidences. The prisoner has programmed in a limited manner while incarcerated and has failed to develop a marketable skill that can be put to use upon release. The psychiatric evaluation dated 7/1/94, authored by Dr. Gates, is not totally supportive of release. The panel makes the following findings. Prisoner needs therapy, and therapy in a controlled setting is needed, but motivation and amenability are questionable. Nevertheless, the prisoner should be commended for being disciplinary-free and upgrading his education. Parole is denied for 2 years. Hearing panel finds it is not reasonable to expect that parole would be granted at a hearing during the following 2 years. Specific reasons for this finding are as follows. Prisoner committed this offense in an especially atrocious and cruel manner. Specifically, he murdered by assassination an American leader and elected public official and injured 5 others in a calculated, planned manner with no regard for the consequences of his act. As a result, a longer period of observation and evaluation is required before the board should set a parole date. Recent psychiatric report dated 7/1/94, authored by Dr. Gates, indicates a longer period of observation and evaluation of treatment. Prisoner has not completed necessary programming, which is essential to his adjustment. Needs additional time to gain such program. Specifically, he needs to develop a saleable skill while he's incarcerated. Panel recommends that the prisoner remain disciplinary-free, continue to upgrade vocationally, and continue to participate in self-help and therapy programming as it becomes available. That concludes the official reading of the hearing. Is there any comments, Mr. Gillis?
No comments.
Mr. Lander?
Get back into AA.
That concludes the hearing, and the time is 2:50 p.m.
Now you owe me one. And if you don't pay me when you owe me, then I'm going to pay you what you owe me. You see what I'm saying?